The state of Tennessee is trying to gag WhistlinDiesel, silence him from talking about his own criminal case. 2 felony tax charges, a hearing tomorrow morning, December 8th, and prosecutors argue that Cody Detweiler's millions of followers are a threat to their case. Here's the problem. Tennessee's own Supreme Court has already ruled on this, and the law is not on the state's side. I'm Brandon Grable, Texas civil rights attorney, and this is clearly established. Let's break down why this gag order is dead on arrival, and what it tells us about how Tennessee has been playing this from the start. Quick background if you're just catching up. Cody Detweiler, WhistlinDiesel, was indicted November 5th, 2025 in Williamson County, Tennessee. 2 counts of tax evasion, both Class E felonies. The allegation: on January 30, 2023, Cody purchased a 2020 Ferrari F8 and allegedly evaded Tennessee sales tax by registering it through a Montana LLC. Count 1 is against him personally, and Count 2 is against WhistlinDiesel LLC. The amount in question? According to Cody, about $27,000 in sales tax. He was arrested a few weeks ago, 5 officers at his door, and he posted a $20,000 bond, waived arraignment. But here's where it gets interesting. After Cody started posting about this publicly, videos that racked up millions of views, the state filed a motion for a gag order. They want him silenced. And that's what tomorrow's hearing is about. Let's hear Cody explain what they're asking for.
If this were to go through on Monday, I would not be able to say anything at all about this case. No videos, no updates. I cannot talk about it.
No videos, no updates, nothing. For a creator whose entire brand is about transparency, showing his audience what's happening is his life. That's not just a legal restriction. That's an attempt to shut down his ability to defend himself in the court of public opinion. But can Tennessee actually do this? Let's talk about what their own courts have said. Here's what the state's lawyers apparently forgot or are hoping the judge doesn't remember. Tennessee already has binding precedent or binding case law on gag orders against criminal defendants, and it's not friendly to what they're trying to do. The case is State v. Carruthers, decided by the Tennessee Supreme Court in 2000. And I want you to understand the facts of that case because they make WhistlinDiesel's situation look like a parking ticket. Carruthers was a death penalty case. Triple homicide. The circumstances included death threats against attorneys, a co-defendant who died under suspicious circumstances, SWAT teams guarding the courtroom, a jailer who was murdered, witnesses fleeing after reading about the case in the newspapers, and the defendant himself threatening witnesses to make them recant their stories to reporters. That's the level of chaos we're talking about. Actual threats, actual violence, actual witness intimidation. And you know what the Tennessee Supreme Court said? Even under those circumstances, the gag order was unconstitutionally overbroad. Let me read that again. Tennessee's highest court held that gag orders must allow defendants to make general statements asserting innocence and to comment on the nature of allegations or defenses. That's not optional. That's the floor. The court also held that before speech is restricted, quote, reasonable alternative measures should be considered, such as a change of venue or a continuation for publicity to lessen. So under Tennessee law, a gag order is supposed to be the last resort, not the first move. And even then, it can't be a blanket ban. Now, I will preface, the only version of the motion for gag order that I have seen is what was posted, or his video. He didn't show the whole thing. But if they're attempting to silence him, it appears to me that it's going too far. The defendant has to be allowed to publicly assert innocence and discuss the defense. Now look at Cody's case. No death threats, no witness intimidation, no violence. A guy just talking on YouTube about what he thinks about the charges and why he thinks they're unfair. If the gag order in Carruthers was too broad, how does Tennessee justify silencing WhistlinDiesel here? It gets worse for the state. Even the federal court that covers Tennessee, the Sixth Circuit, has precedent directly on point as well. In 1987, Congressman Harold Ford out of Memphis, Tennessee, was charged with mail and bank fraud. The district court slapped him with a broad gag order prohibiting him from discussing the merits of the case publicly. Does that sound familiar? Well, the Sixth Circuit struck it down. The court wrote, "Such broadly based restrictions on speech in connection with litigation are seldom, if ever, justified." But here's the part that really matters for Cody's situation. The government in that case argued, if Ford gets to talk publicly, the coverage will favor him. That's not fair to us. And the Sixth Circuit's response? Read that carefully. The court said the Sixth Amendment's fair trial guarantee belongs to the defendant, not the government. The state doesn't get to complain that Cody's videos are making him look sympathetic. That's not a legal harm. That's called a guy defending himself. Let's zoom out for a second and talk about what a gag order actually is in First Amendment terms. It's called a prior restraint. Government action that prevents speech before it happens rather than punishing it afterward. And in constitutional law, prior restraints are the most disfavored form of speech restriction. The Supreme Court has called prior restraints the most serious and least tolerable infringement on First Amendment rights. They carry a heavy presumption of unconstitutionality. That basically means that you start by assuming and operating that it's wrong. And then the government has to overcome that presumption. And so to overcome that presumption, the government has to show an imminent threat to fair proceedings, and that no lesser alternative would work. Tennessee has its own constitutional provision on this too. Article 1, Section 19 of the Tennessee Constitution says, "The free communication of thoughts and opinions is one of those invaluable rights of man, and every citizen may freely speak, write, and print on any subject, being responsible for the abuse of that liberty." So Cody has protection under both the U.S. Constitution and the Tennessee Constitution. The state has to clear two constitutional hurdles, not one. Here's the part that should bother everyone. Regardless what you think about the underlying tax charges.
So on this page, they have a screenshot of my merch for sale. You know what my merch has on it? Which, thank you guys for buying it. That actually, my legal fees are still more than what sold in merch. But you know what my merch has on it is the public indictment page that they posted when someone gets arrested. Anybody can access this. It was already public. All I did was draw a lot more attention to it. So that has, it's public. It has names on it, and mostly the Department of Revenue is responsible for this. So the fact that my First Amendment right is being tampered with is insane.
The state's motion specifically complains that Cody is monetizing this, selling merch with the indictment on it. But here's the thing. The indictment is a public document. The state filed it. It's on court records. News outlets have been covering the story. YouTubers have been covering it, running his mugshot, analyzing the charges, and monetizing that coverage through ads. But when Cody talks about his own case, suddenly that's a threat to fair proceedings? Shepard v. Maxwell, the Supreme Court case that recognized the public discourse about criminal cases, serves important functions. Transparency keeps the system honest. The solution to prejudicial publicity isn't silencing the defendant while everyone else talks. It's robust voir dire, or jury instructions, change of venue if necessary. Those are the alternatives that Tennessee courts are supposed to consider first under Carruthers. So ask yourself, if the concern is really jury contamination in Williamson County, why isn't the state proposing a venue change? Why isn't the solution to carefully have jury selection? Why is the first move right out the gate to silence the defendant while the media outlets keep profiting off the story? Now here's where this gets really interesting and why the gag request feels less like legitimate trial protection and more like the state trying to control the narrative after they already got caught playing games.
A special agent, I guess, from the state called my accountant, and they asked her all these questions. They said, do you give Cody financial advice? They asked some questions about Montana LLCs, and they were kind of digging. It says in the document, she called them back and asked if there was a problem with Dewiler's Montana registrations. She asked if we should move all of the Montana assets to Tennessee. In other words, register them in Tennessee and pay the sales tax. The accountant was advised not to speak to Dewier about the conversation and to leave assets as they were until the investigation was complete. That was a year ago.
Let that sink in. According to Cody, a year before this indictment dropped, state investigators were already in contact with his accountant. When she proactively asked, "Is there a compliance problem? Should we just register the vehicles in Tennessee and pay the tax?" she was told, "Say nothing to Cody, change nothing, let us finish our investigation." If that account is accurate, the state was managing the flow of information long before Cody ever posted a video. They had the opportunity to collect the tax, but they chose to build a criminal case instead. And now they want a court order controlling his speech? That goes to what lawyers call the equities, considerations a court weighs when someone asks for extraordinary relief like a gag order. You don't get to play information games for a year, instruct someone's accountant to keep him in the dark, build a case in secret, arrest him at his home with 5 officers, and then come into court and claiming he's the one threatening fair proceedings because he talked about it? Under Carruthers, the court has to consider alternatives before gagging someone. Here's maybe an alternative. Don't run a secret investigation and then act surprised when the target talks about it publicly. So what's likely to happen at tomorrow's hearing? Well, under Tennessee law, under Carruthers, the court has to weigh several things. First, is there a compelling government interest? Standard pretrial publicity concerns generally don't cut it, especially when the defendant hasn't threatened anyone or tampered with any witnesses. Second, has the state considered less restrictive alternatives? Venue change, careful voir dire, jury sequestration, continuance? No, of course not. It's too early. And if those options haven't been exhausted, a gag order shouldn't be on the table. Third, even if some restriction is warranted, does the proposed order allow Cody to make general statements asserting his innocence and commenting on the nature of the defense? Under Carruthers, it has to. Fourth, is it narrowly tailored to a specific identified harm? Think about that. They have to have a specific harm. Just because Cody is popular, garners millions of views, what is the real harm? A blanket ban on all social media posts about the incident? That to me sounds overbroad. My prediction, the court either denies the gag outright or narrows it dramatically. Otherwise, there's a risk that this matter goes to appeal. But a total ban on Cody discussing the case across all platforms is inconsistent with Tennessee Supreme Court precedent. They might get a very narrow restriction, like maybe prohibiting comments about specific witnesses or sealed evidence, but stop posting entirely? That should not be happening. Not if the judge follows Carruthers and other case law. One more thing before I let you go. This matters beyond WhistlinDiesel.
If they stopped with, if they did this to me, they're not stopping with me. This is going to happen to other people. This just shows what they will do.
He's right. The theory Tennessee is pushing here, that a large social media following justifies speech restrictions, has implications for every creator, every influencer, every person with the platform who ends up in the legal system. The First Amendment doesn't treat people differently. Think about what they're really arguing. You're too good at communicating. Too many people listen to what you say, so we need to silence you. That's not how the First Amendment works. The Sixth Circuit said it plainly in Ford. The defendant gets to defend himself publicly, even if that makes coverage of him more favorable. That's not unfair to the government. That's the system working. This isn't about whether Cody owes tax on a Ferrari. That's a factual question for trial. This is about whether Tennessee, a government, can silence a defendant for being effective at telling his side of the story. And under decades of precedent, both federal and Tennessee state law, the Constitution, the answer is no. That's my breakdown. I'll post an update when we know more. If you found this helpful, hit subscribe. I cover civil rights, constitutional law issues like this regularly. I'm Brandon Grable. This is Clearly Established. Know your rights, and thank you for watching.